Justice Kagan?
Mr. Fisher, I want to talk to you about the life on a blank slate. So pretend that the precedents don't exist for a moment. I do want to come back and ask you about the precedents, but pretend that they don't. And make it really blank. Like, it doesn't seem to me that you're required to say, well, we first argued it in a non-strict scrutiny way, because obviously you argued it in that way. You were defending federal statutes. That was the most natural way to defend them. So I want to take out the fact that your first argument was the not strict scrutiny argument and really say, as you're standing here on a blank slate, it seems to me that there are possible spillover dangers either way. One is the spillover danger of you relax strict scrutiny in one place, and all of a sudden strict scrutiny gets relaxed in other places. The other is the spillover danger of you treat a clearly content-based law as not requiring strict scrutiny, and all of a sudden you start seeing more content-based restrictions that don't have to satisfy strict scrutiny. And I just want to ask you, like, how you weigh those dangers. And I read you as saying it's just got to be the case that states can do some regulation in this area. And the question is, how does that happen? Does it happen by notching down the strict scrutiny standard, or does it happen by saying, for some reason, which we'll figure out how to articulate, this set of restrictions comes outside it?
Yeah. So you read me correctly, and I think writing completely on a blank slate, I genuinely think there would have been two reasonable ways to deal with this problem. It really is a unique feature in the First Amendment where you have the same speech that's protected as to some people and not protected as to others. And in fact, everyone agrees the government has a compelling interest in restricting access to that speech based on its content. It's a special, I think, unique problem. One way to approach it would have been, as you say, to say something less than strict scrutiny, even though it's content-based. Another approach, the one I'm advocating here, would be to say strict scrutiny applies a little bit differently. I would resist the idea that it's watering it down. I think it would be to say the regular strict scrutiny standard just applies differently because of the special features here. As a matter of first principles, I'm not trying to duck the question. I'm genuinely saying I think either of those would have been sort of equally workable, but we're not writing on a blank slate, so this is fighting the hypo a little bit, but I think this is what tips the scales.
It's the next question I was going to ask, which is, what about Ashcroft and all our other decisions makes you think that they're simply not distinguishable in the way one might want to distinguish them?
I mean, I think Ashcroft is particularly hard because that was a law that looked in terms almost exactly like the law at issue here. I take Justice Barrett's point that their age verification was an affirmative defense rather than part of the law, but the substantive requirements that the law imposed in effect were basically exactly the same. And also, I think just the logic of the court's opinions leading up to that in the earlier line was defining sexual material that is harmful to children, this category of material that kids can be prohibited from seeing. That, the court said over and over again, is a content-based restriction. And I think that then starts to bring in, and this gets to complete my answer to your earlier question about why I'm more worried about, I think it was the second category of spillover effects than the first. That starts to bring in not just this particular corner of the First Amendment law, but also this court's cases like City of Austin and Reed and all of the other places where the court has laid down this is what it means to have a content-based law. And I worry a little bit that if you start now trying to carve back on Ashcroft and those other cases, you would have spillover into those broader areas of First Amendment law, whereas recognizing, as we've suggested, that strict scrutiny functions differently here is very limited to this particular corner of the law.
Thank you.